Thank you very much, everybody. As I just said, it is a webinar on me on the road, but I'm extremely privileged for the opportunity to moderate it. I welcome everybody on behalf of the organizers who are the Open Society Justice Initiative and the East Africa Law Society. My name is George Kegoro, as the screen would show. I work for the Open Society Foundation, so the Open Society Africa, which is part of the Open Society Foundations. So I welcome you all to the webinar. Welcome all the panelists who will give themselves further introduction when they come to speak. This webinar is on the topic of the externalization of asylum seeking. The context is that the United Kingdom and Rwanda have entered into a treaty through which the former seeks the cooperation of the latter to externalize or to handle on its behalf all cases of asylum seekers on Rwandan soil. That arrangement has been challenged successfully before the judicial authorities of the United Kingdom that have pronounced themselves and said that it is actually an illegal arrangement. However, in response, the United Kingdom Parliament has then passed legislation that seeks to override the findings of the courts. The East Africa Law Society, which is a partner of the Open Society Foundations, is part of the group of organizations that have been involved in that litigation. So there's a lot of authority for here to speak about the concerns that have led to that challenge in the first place. But there's also significant authority because as part of the panelists, we have got the representative of the Rwandan government that has directly negotiated the treaty that is now the subject of discussion, that is also the subject of the litigation that I referred to. So, in a sense, externalization is old. This concept of externalization is old, but it's also something that we don't necessarily well understand together. So, in the absence of specific objectives being given to me by the organizers, I think it's a reasonable objective that we should emerge from this conversation with a shared understanding of what externalization means and how it has evolved over time, what its implications are for in terms of the protection of refugees under international law and also under international refugee law and also under international human rights law, and the concerns that have been raised and that have given rise to the litigation and the conversation that we are having here. I hope that we can also emerge from this conversation with a shared understanding of how, if possible, what seems to be a controversy now can be resolved possibly amicably, but if not, then through a further conversation and maybe possibly litigation. We have Sushila Math, who works with the Open Society Justice Initiative. She will be the first speaker. She will provide foundational information through a keynote address on the subjects of externalization and what has happened around the United Kingdom Rwanda cooperation. That will ground further conversation by the other panelists, whom I will introduce more clearly once Sushila has finished her presentation. So without further ado, Sushila, you've got the floor. Thank you very much.
Thank you so much, George. So, sorry, I just need to try and apologies. I just need to exit out of this view so I can see my notes. So there we are. See. Okay, great. Sorry about that. So thank you so much for the introduction, George, and good afternoon, everyone, if it is indeed afternoon where you are, which of course it will be if you are joining us from the East Africa time zone. Thank you for your interest in this topic, which I believe gives rise to, as George touched upon, issues of fundamental importance to both regions, as well as the wider global asylum framework, and indeed the very essence of the rule of law. So I'm going to start by giving you a bit of background, firstly on our interest in this matter, but more importantly on the factual, legal and political background to the UK-Rwanda deal, and then I'll move on to some of the grave concerns that are arising. So first of all, I'm a Scottish solicitor by way of background and subsequently qualified in Ireland and England and Wales as well. As George mentioned, I'm a Senior Managing Litigation Officer at the Open Society Justice Initiative, which is a programme of the global organisation Open Society Foundations. So we at the Justice Initiative are focused on strategic litigation and other forms of legal advocacy to empower people, defend the rule of law and advance human rights around the world. This includes in relation to migration and asylum laws and practices in the framework of international and regional human rights standards, bearing in mind the impact of such laws and policies on the rights of minorities and other vulnerable groups. So as such, we at the Justice Initiative have a specific interest in this topic, and although we've not been in the case law directly, in the litigation directly, we have been following closely the developments of the UK courts and the European Court of Human Rights as well. So turning now to the background of the UK-Rwanda arrangements, by way of summary of the factual background, on the 13th of April 2022, the governments of Rwanda and the UK entered into a memorandum of understanding regarding the asylum process of so-called transferred individuals and their reception and accommodation. And this memorandum of understanding relates to UK legislation known as the immigration rules, primarily paragraphs 345A to 345D, under which an asylum claim can be ruled inadmissible, with the consequence that the merits of the claim need not be considered, in circumstances where essentially the asylum seeker was deemed to have had the opportunity to seek asylum in a prior safe country before they got to the UK. In these circumstances, the asylum seeker can be removed either to that country or, and this is the part that's of most relevance to us today, any other safe third country which agrees to accept him or her. So following the Memorandum of Understanding, the Secretary of State's policy was essentially to remove such asylum seekers to Rwanda on the basis that it is another safe third country which has agreed to accept them. So this policy and specific removal decisions that were made in respect of some individuals were challenged in the UK courts. So in this litigation, as well as individual claimants, a number of interested organisations took part in the proceedings before the courts, and the United Nations High Commissioner for Refugees, so UNHCR, or the UN Refugee Agency, was permitted to intervene. And before I touch on what happened in the UK courts, it's worth noting that on the 14th of June 2022, one of the claimants, NSK, an Iraqi national, was successful in obtaining interim measures from the European Court of Human Rights, which basically stopped the removal flight to Rwanda on the basis of the risk of treatment contrary to his rights under Article 3 of the European Convention on Human Rights, which is the prohibition on torture and inhuman and degrading treatment. And I'll come on to speak a bit more about that article shortly. But on the 19th of December then, following that in 2022, the Administrative Courts, the Divisional Court of the High Court of Justice in London, found in favour of the claimants on the basis that the way that the Secretary of State had implemented their decisions was procedurally flawed. So, for example, they'd failed to consider all relevant information, there were factual errors and so on. A wider challenge to the policy as a whole was rejected, but it was successful on appeal, with the Court of Appeal finding on the 29th of June 2023 that there were substantial grounds for believing, notwithstanding the guarantees that Rwanda and the UK had agreed to in the Memorandum of Understanding, that A, there were real risks that asylum claims would not be properly determined by the Rwandan authorities, and B, that in consequence of that, there were real risks of refoulement, which I will talk a bit more about shortly. The case then went on to the Supreme Court, which is the apex court in the United Kingdom, which gave its judgment on the 15th of November 2023, again in favour of the claimants, essentially ruling that the policy is unlawful. So in giving its judgment, the Supreme Court began by exploring this principle of non-refoulement, which it noted is enshrined in several international treaties which the United Kingdom has ratified, including the 1951 Refugee Convention, and that it's also been incorporated into the case law of the European Convention on Human Rights under Article 3. And finally, that it has been given effect in domestic law also in a number of different pieces of UK legislation. Non-refoulement is basically a prohibition on returning refugees to a country, such as their country of origin, where they are at risk of torture, ill treatment, persecution, and so on. The Supreme Court reaffirmed that the test that it needed to apply is whether there are substantial grounds for believing that the removal of asylum seekers to Rwanda would expose them to a real risk of ill treatment as a consequence of refoulement to another country. And this requires an examination of how the asylum procedure operates in Rwanda. Because, as Lord Reid explained when he was presenting the judgment on the day, if there is not an adequate asylum system which properly evaluates claims, genuine refugees may be returned to their country of origin, where they can be tortured or otherwise mistreated. So the Supreme Court carried out this assessment, and in doing so, it gave a lot of weight to evidence by UNHCR, both because of UNHCR's special role and status under the 1951 Convention and other instruments, but also because it has unrivaled practical experience of the workings of the asylum-seeking system in Rwanda through long years of engagement there. And the Supreme Court ultimately agreed with the Court of Appeal that asylum seekers would face a real risk in the event that they were removed to Rwanda from the UK. And again, that's a risk of ill treatment by reason of refoulement back to their country of origin. This conclusion was based on evidence of the general human rights situation in Rwanda, the adequacy of the asylum system, including the history of refoulement, even after the MOU was signed, and Rwanda's non-compliance with assurances that it had given under a similar previous arrangement with Israel. The Supreme Court was at pains to emphasise that while it believed that both governments were acting in good faith, their intentions and aspirations didn't necessarily correspond to reality, and that the issue was with the practical ability to fulfil the assurances, at least in the short term, because of the scale of the changes in procedure, understanding and culture which were required. So that is the legal position. And on the day of the judgment, everybody, including all of the expert commentators and so on, assumed that this was the end of the Rwanda policy, also bringing the claimant's need to continue pursuing the matter in the Strasbourg court to an end. And of course, because the UK government, of course, can't appeal to the European Court of Human Rights because it's not a victim, and so that was the end of the legal proceedings. But the UK government, which is made up of the ruling Conservative Party, and politicians from the party had completely different ideas. So on the very same day, very shortly after the judgment came out, the deputy chairman of the Conservative Party stated that ministers should go ahead and put planes in the air to Rwanda anyway. And when he was asked by the media if he was suggesting that the Supreme Court ruling should be ignored, he replied that the government should ignore the laws and send them straight back. And later the same day, the Prime Minister made a statement that was very clear that he would be proceeding as planned by upgrading the Memorandum of Understanding to a treaty, which was in fact subsequently signed by the countries on the 5th of December, and also by introducing emergency legislation, which we'll look at in more detail shortly. And it's called the Safety of Rwanda Asylum and Migration Bill. So that's the background. And I'd now like to focus on two of the key issues arising. The first is the implications of the externalisation of asylum in general, and then connected to that, secondly, the implications for the rule of law. So on externalisation, first of all, what I mean by this phrase is, as George kind of touched upon, is the state transfer of asylum functions to take place outside of the state's borders, including this type of use of a third country for the processing of asylum claims. And as George mentioned, these measures are not new. For example, back in 1994, there was a joint communique on migration between the Cuban and the US governments, which basically stated that Cubans rescued at sea attempting to enter the US would not be permitted to enter and instead would be taken to what was called safe haven facilities outside the US. And Australia commenced offshoring policies back in 2001 primarily. So these aren't new, but there does appear to be a growing trend of externalisation. And just a couple of recent examples include the Rwandan agreement with Israel that I mentioned, and a joint statement was made between Denmark and Rwanda in September 2022, but hasn't actually been put into practice as yet. So what is the problem with the externalisation of asylum? So from my point of view, there are three things that I would highlight. Firstly, and most importantly, the impact on some of the most vulnerable members of society, asylum seekers. UNHCR has warned that externalisation practices often result in the transfer of people from one country to another without adequate protection, safeguards, or standards of treatment, that they can expose asylum seekers to dangers, and that they may also dehumanise asylum seekers and label people in need of international protection as unwanted. And building on that, Human Rights Watch has reported that Australia's offshoring policies have caused immeasurable suffering for thousands of vulnerable asylum seekers, including death by suicide of 7 people in camps and the traumatisation of children as young as 5 reportedly attempting suicide. There was also at least 1 murder and 2 deaths from medical conditions after access to appropriate treatment was delayed or denied by Australia. In 2017, the UN Special Rapporteur on the Human Rights of Migrants concluded that Australia's responsibility for the physical and psychological damage suffered by these asylum seekers and refugees is clear and undeniable, and that it's a situation that is purposely engineered by Australian authorities to serve as a deterrent for potential future unauthorised maritime arrivals, which takes me to my second point, which is the issue of whether these types of measures are effective in that sense at all. So research carried out, for example, by the Caldor Centre for International Refugee Law at UNSW Sydney concluded that offshoring has not been an effective deterrent to irregular maritime migration to Australia. And indeed, recently it has come to light through papers that were released that the UK Prime Minister, who was Chancellor at the time when the Rwanda deal was being finalised, in fact, had expressed huge doubts about the plan, saying that he believed that the deterrent won't work and that he was concerned about the cost. And indeed, the cost has risen from the initial £140 million to £290 million by 2025, despite no migrants having left the UK. So The third point that I want to mention on externalisation is the impact on the whole global agreement and framework on asylum, including knock-on effects within particular regions. So UNHCR is clear in its position that asylum seekers and refugees should ordinarily be processed in the territory of the state where they arrive or which otherwise has jurisdiction over them, and that it strongly opposes efforts seeking to externalise or outsource asylum and international protection obligations to other countries, because such efforts to evade responsibility run counter to the letter and spirit of the 1951 Refugee Convention, as well as, for example, the Global Compact on Refugees, where countries agreed to share the responsibility for refugee protection. And indeed, UNHCR often makes reference to the widely accepted principles of international cooperation and solidarity in this regard, which are obviously undermined when more burdens are placed on regions that are, as you can see from the previous slide, disproportionately burdened already. So for Rwanda in particular, for example, in relation to another piece of UK migration legislation that was passed last year, the Law Society of England and Wales warned that that is an unworkable piece of legislation, including because there is only one removal agreement in place, that's the one with Rwanda, and that Rwanda alone would not be able to accept anywhere near the number of people who will be scheduled for removal. And it's worth just noting that the African Charter on Human and People's Rights reaffirms solidarity and friendly relations between its member states, whilst the convention governing the specific aspects of refugee problems provides that where a member state finds difficulty in continuing to grant asylum, it can appeal directly to other member states and through the AU, and that in the spirit of African solidarity and international cooperation, they shall take appropriate measures to lighten the burden of the member state granting asylum. So a potentially overburdened country in the region could therefore have knock-on effects with other signatories and undermine those principles of solidarity within the region. And so coming to the crux of this webinar, by turning to the other rule of law issues arising. So I've already touched upon the ones articulated by UNHCR, which is essentially the weakening of the whole legal asylum framework in general. But the UK and Rwanda example gives rise to further specific grave rule of law concerns. So on the day of the Supreme Court judgment, the UK Prime Minister made a statement that the rule of law is fundamental to the UK's democracy, but in the same breath announced that Rwanda would be declared a safe country to send asylum seekers, which of course is in direct contradiction of the Supreme Court's findings the same day, that it's not such a country. And he went on to say many things, including that no foreign court would stop the flights, even though it was, of course, a domestic court that had reached the ultimate decision. Now, in its judgment, the Supreme Court expressly rejected an argument by the Secretary of State that assessing the value of the asylum assurances given by another country, such as Rwanda, is analogous to assessing a measure in whether it's in the interest of national security, and that the role of the court is correspondingly limited. The Supreme Court said, well, no, even in the context of national security, the executive enjoys no constitutional prerogative in relation to rights under Article 3. So in other words, the court should assess if there is a danger of torture, and if there is, the government needs to find some other way. In the present case, the Supreme Court made it clear that it's required by law to form a view as to whether there are substantial grounds for believing that asylum seekers who are removed to Rwanda are at risk of refoulement in light of all of the evidence bearing on the issue. And it said that the government's assessment is an important element of that, but the court is bound to consider the question in light of all of the evidence as a whole and to reach its own conclusion. So the question arises now, given what the UK government is doing, can the UK government just legislate across all of that? Well, as I'm sure all of you are aware, the UK's constitution is famously an unwritten one. And this whole issue brings to mind my constitutional law professor's teachings, Professor Jim Murdoch, about the hugely influential constitutional lawyer Dicey on the principle of parliamentary sovereignty. And in my professor's words, Dicey 1 is Parliament can do anything, and Dicey 2 is nobody can stop it. But obviously in modern times, for many years now, the question has been asked, is that really true anymore? In the context of all of the international treaties, the treaty monitoring bodies, tribunals and courts, and obviously the UK was part of the EU for many years, and it was used to this idea of supreme law outside of the UK Parliament. And of course the answer to that was to Brexit out of it. But aside from that, there is also Scotland's constitutional settlement, which bakes human rights into public law in the way that devolution is set up. So where does this bill leave the rule of law? And even aside from that, the UK's international standing? Well, the Law Society of Scotland, for example, has stated that it's very concerned about the bill, and particularly sections that would undermine the independence of the judiciary, along with the UK's commitment to human rights and international law, saying that our international reputation is in jeopardy. And the Society points particularly to the ministerial statement accompanying the bill that makes clear that the Secretary of State is unable to say that it is compatible with the European Convention on Human Rights. And you'll see on the screen there that the President ended her quote by saying that, emphasising that the UK must comply with its international obligations or be in breach of the rule of law. And the UK Parliament's Joint Committee on Human Rights published a 15-page briefing paper setting out its concerns, including a statement that Parliament cannot legislate out of its existing international obligations. So for me, the key rule of law issues arising from this bill can be summarised as follows. Firstly, as I mentioned, in contradiction of the Supreme Court's independent evidence-based assessment, the bill seeks to declare that Rwanda is a safe country and that every decision maker must conclusively treat it as such. And secondly, in doing so, it clashes directly with the finding of the Supreme Court that I mentioned earlier, that the courts are required by law to make their own assessments on the question of safety and the risk of refoulement. Thirdly, in general, it contravenes the principles of the separation of powers and the independence of the judiciary, or in other words, not being controlled by other branches of government in this way. And fourthly, the bill expressly orders British courts and judges to ignore any obligations, including international ones, that contradict Parliament's assessment of Rwanda as a safe country. And it specifically disapplies the Human Rights Act and also says that interim measures decisions from the Strasbourg court should be ignored in this issue about Rwanda being safe. This bill passed its second reading on the 12th of December last year. And shockingly to me, many in the Conservative Party are still not happy, and they have tabled many amendments that go even further, essentially aimed at ensuring that UK and international law cannot be used in any way on this issue to prevent or delay a person being removed to Rwanda and to limit individual asylum seekers' ability to appeal. And there's been a very high-level rebellion. The Deputy Chairman has resigned because these amendments have not passed. They've not been accepted, but the bill as a whole did pass last night in the evening on the third reading of the bill, so it is going forward. And the Home Secretary made a very interesting statement saying government, that he's absolutely confident that we will maintain our long-standing tradition of being a country that not just abides by international law, but champions and defends it internationally, which I think takes a lot of explanation given what's in the bill. So this bill will continue to make its way through Parliament, and it is likely to face some objections in the House of Lords. But as I personally think there's been a real lack of debate about the rule of law, leaving aside the politics of asylum altogether. But assuming the bill does pass and becomes law, presumably the government's plan is to ignore any rulings in the UK, which are known as declarations of incompatibility with human rights standards in due course, and also presumably to then ignore any judgments from the European Court of Human Rights or any other body. And of course, in this context, there is very much a continued political focus on the UK's relationship with international law and huge pressure, as I was saying, from many politicians to simply not comply with it. And as the Supreme Court emphasised, it's not just the European Convention on Human Rights that prevents the UK from doing what it's trying to do, although that tends to be what people focus on. but it's also these wider international treaties, including UNCAT and the ICCPR. And the Prime Minister has said that he is willing to revisit all of these relationships. And so, as other commentators have noted, the UK is now essentially deciding that it won't comply with whatever it doesn't want to comply with, but at the same time, it is demanding that Rwanda does exactly that. And Professor Mark Elliott of Cambridge University, for example, has blogged that this is an outstanding level of hypocrisy. And it also raises the question for me of why Rwanda would want to be associated with the UK in these circumstances. And although Rwanda objects to being considered an unsafe country, it did issue a statement in December that it's always been important to both, it says, Rwanda and the UK, that its rule of law partnership meets the highest standards of international law, and without lawful behaviour by the UK, Rwanda would not be able to continue with the partnership. So to conclude, there are many and serious rule of law issues arising from this matter, and I'm really interested in all of your thoughts on what we can do as the international legal profession to protect the rule of law in this context, and however much it's denied fundamental UK principles, not just foreign ones as they're often labelled, particularly when successful legal challenges end with more of these threats to Brexit out of any international or indeed domestic law that stands in the way. And, you know, it goes without saying that human rights and respect for the law impact all of us, not just the most vulnerable, such as asylum seekers. So it's obviously crucial that they are protected. And so I really look forward to this discussion. Thank you.
All right. Thank you very, very much, Sheila, for what has been an excellent presentation that gives a history of the treaty between the United Kingdom and Rwanda, the journey that that has traveled, the challenges that have been raised, how attempts to resolve those have panned out, and the controversies that those attempts have raised. You've also covered the key concerns about the arrangements between the UK and Rwanda, and those concerns are also the basis of the challenges. And you've also given a comparative information about similar arrangements relating to externalization in other parts of the world. And I think you get with a suggestion that this is still a matter very much in progress, has huge implications, not only for asylum seeking, but also for the interbranch relationship in terms of the UK's domestic politics, the relationship between its judicial authorities and its executive authorities. Quite aside from the fact that this is a refugee asylum seekers issue, and through which that the challenge in those relationships is playing out. So I think that sets the stage for listening to the next presenter, who is Dr. Doris Uwisheza Picard. She's a representative of the Ministry of Justice of the government of Rwanda and was involved in negotiating the treaty in place. We are grateful that you've been able to join us for this presentation, because what often happens is that people in official authority sometimes don't readily come to conversation with people like ourselves in the civil society space. They kind of speak in the office, so it's nice that you have come to share your views, and it's nice to know how the Rwanda government interfaces with the unresolved issues that concern the public authorities of the United Kingdom. And I can then also use this occasion to introduce the two other remaining panelists. That is Evans Ogada, who is the chair of the East African Law Society Rule of Law Committee. Is actually my friend. Thanks very much, Evans, and is a lawyer admitted to practice in the Kenyan bar. The other one is Donald Dare, who is the Chief Executive Officer of the Pan-African Lawyers Union, and a very, very notable Pan-Africanist, and a person who would also obviously have a significant experience and insights to share on this conversation. But let's first hear Doris before we come to the other two speakers. Doris, you've got the floor.
Thank you very much, George, for this introduction. And I'd like to begin by thanking the East African Law Society for extending the invitation to us. As George said, it is not often that governments are involved in these discussions, but I also believe that it's not often that we get invited. So I do thank you for including us in this conversation. And I'd like to also thank Sushila for her presentation. I believe it captured the essence of this discussion. And just to pick up on something that she said at the end, why Rwanda would want to be involved in this. You know, I know we're all lawyers, and so this discussion is really on the rule of law, but I would like to begin by addressing that. Why would Rwanda be involved? It's about, you know, our moral imperatives, and you know that moral imperatives inform the creation of laws and agreements. So Rwanda, as you know, we are a young nation. We consider ourselves a young nation, as a 30-year-old nation, because we just came, that was when the genocide against the Tutsi ended. But prior to that, the genocidal government had enacted such policies that Rwandans were refugees and displaced. And even, you know, during the genocide, most Rwandans, during the genocide and the aftermath of the genocide, Rwandans were displaced and refugees. So in essence, we are a refugee nation. We were all refugees. I myself was a refugee. This is one of the reasons why Rwanda is always trying to be at the forefront of this crisis, of this refugee crisis, and trying to find solutions, because we know what it is like to be a refugee. We know what it's like to be to find asylum in a country, in a society that may not always be very welcoming to you. So we're always putting as a priority the dignity and the rights of asylum seekers and refugees and migrants, because we know what it's like to go through that. So just as a quick reminder that this UK-Rwanda partnership is not an offshoring partnership. I understood some very valid concerns about the impact of offshoring on the mental health of asylum seekers, but this is not such an agreement. This is an agreement whereby asylum seekers would be relocated from the UK into Rwanda, and then Rwanda would process their claims, and then they would be given refugee status for those who are refugees, and they would be resettled or any other status, and they will be settled in Rwanda. So this is not an offshore processing center. So we're trying to bring people here to live happy, prosperous lives in a society that is very welcoming to them, that understands what they're going through. Rwanda is already host to more than 130,000 refugees, and we've worked mostly, they are mostly from our neighboring region. And we worked in close partnership with the UNHCR to receive and accommodate those refugees. We are also, I don't know if you recall, when President Kagame was chair of the African Union, and he proposed at the same time that he was chair, there was this crisis that is still ongoing, the Libya migration crisis, whereby migrants were going to Europe through Libya, and they ended up with the war in Libya. They ended up stranded there, and they were being, and I know every one of you remember the slave auction blocks videos that were circulating, whereby these migrants and asylum seekers were enslaved, tortured, detained in appalling conditions. So while everyone was wondering, how can we come up with a solution? President Kagame was at the time a chairperson, offered Rwanda as a safe country where the migrants that are and asylum seekers that are in Libya can be brought. So, and we have worked in partnership with the AU and UNHCR to bring asylum seekers from Libya to Rwanda. So the concept, the principle of itself is not new, right? The only novelty with this is that we're concluding a formal agreement with a country, with the sending country, to a receiving state such as Rwanda. But this is something that we've always done. So on the legality of this concept, you know, the transfer of asylum seekers, it's a it's a mechanism of asylum seeker protection, really, that entails international cooperation in addressing the global migration crisis within the spirit and purpose of the Refugee Convention. When we recently concluded the treaty, this treaty and this previous iteration in the forms of an MOU, a Memorandum of Understanding, it was the understanding that there should be a burden and responsibility sharing. This is a burden and responsibility sharing endeavor with the aim to improve the protection of asylum seekers by providing those asylum seekers who reach the UK illegally and therefore cannot have their claims assessed by the UK, to give them a place where they can claim asylum and settle. No one wants to live in a place illegally. It is also aimed at breaking the business model of people smugglers who are placing asylum seekers and migrants at tremendous risk. Just 3 days ago, 5 people died crossing the channel to the UK. This is something that benefits people smugglers. No one else benefits from the smuggling of people. So by trying to break this partnership is this consideration that we can break this model and we can provide people with safety and opportunities in a safe third country that can receive them. The concept of asylum seeker transfer between states is not prohibited by the Refugee Convention or any other principle of international law. There is nothing in the Refugee Convention that prohibits the transfer of asylum seekers to a third country willing to offer them international protection. And there is no requirement under international law that an asylum seeker needs to have a connection to that third country that is offering protection. And equally, asylum seekers do not have an unfettered right to choose a country of asylum. So we need to consider all of this and then understand that a lot of reports on this partnership, we always consider it a breach of the Refugee Convention. But one thing you will note is that no one can pinpoint exactly what part of the Refugee Convention is being breached. And considering this is a relatively new initiative, the transfer of asylum seekers is not regulated by a specific treaty or principle under international law. It is regulated by bilateral or multilateral arrangements between states. For instance, this Uk-Rwanda treaty. It is subject to the consent of the sending and receiving states. So as long as it is consented to by the sending and the receiving states, the principle of an agreement to relocate asylum seekers to a third country is as legal under international law as any other bilateral or multilateral agreement. So even though, this concept is new, generally unregulated, the rights of refugees and asylum seekers are not new. They are quite regulated. So it entails obligations on both the sending and receiving states that must be adhered to. It would be illegal under international law for states to conclude asylum transfer agreements that would violate the international human rights of asylum seekers. So the transfer of asylum seekers involve individuals whose human rights must be scrupulously respected. So to ensure this, the human rights standards of the receiving country, in this case Rwanda, must be commensurate with the standards contained in the Refugee Convention and core human rights instruments. Rwanda, just as like the UK, is a party to the Refugee Convention and its protocol, and is a party to all major international and regional human rights conventions. These human rights standards are also entrenched in the Rwandan Constitution and Rwandan laws. And although you've probably seen reports of the UNHCR being completely opposed to this, partnership, to this treaty. Prior to the announcement of this partnership, the UNHCR had a completely different perspective on this. And it stated in its policies that with regards to transfer of asylum seekers, it stated in two main documents, which is the UNHCR guidance note on bilateral and/or multilateral transfer arrangements of asylum seekers, published in May 2013, and the legal considerations regarding access to protection and a connection between the refugee and the third country in the context of return or transfer to safe third countries, published in April 2018. So prior to the announcement of this partnership, in policy, the UNHCR was quite open to this principle of responsibility sharing through the transfer of asylum seekers. And in practice, UNHCR, it was a signatory to the MOU with the African Union, and in what I previously mentioned, which is the emergency transit mechanism. It provided for the evacuation of asylum seekers from Libya and their transfer to Rwanda for their resettlement, either in Rwanda or in any other third country. UNHCR recognizes that the concept of a bilateral or multilateral agreement on the transfer of asylum seekers cannot in and of itself be considered illegal under international law. So it confirms that under international law, there is no requirement for a connection between the asylum seeker and the third country of reception. So while expressly acknowledging that bilateral transfer agreements are a viable mechanism for the international protection of asylum seekers, UNHCR notes that the appropriateness of a transfer agreement is to be assessed on a case-by-case basis. It is legal, but is it appropriate? Would be the question. And UNHCR in its guidance notes highlighted some elements that must be included in the transfer agreements to guarantee the rights of transferred individuals. And according to the UNHCR itself, transfer arrangements must guarantee that, one, asylum seekers will be individually assessed as to the appropriateness of the transfer, subject to procedural safeguards prior to transfer. Procedural safeguards for instance, the relocation of unaccompanied children and other vulnerable groups. And I don't know if you've had the chance to read the Uk-Rwanda MOU or the recently signed treaty. You will see that this is provided for. The appropriateness of a transfer of each specific individual is assessed before transfer. Even Rwanda also assesses the appropriateness of the transfer before approving the relocation of that person to Rwanda. Another requirement, the second requirement, is that the sending state must guarantee that the asylum seekers will be admitted by the receiving state. The entire purpose of this treaty is that Rwanda will be admitting asylum seekers and migrants in Rwanda. A third requirement is that they have to be protected against refoulement. And refoulement, and Rwanda is a party to the Refugee Convention, so already we have to abide by the principle of non-refoulement, and we have done so with regards to all the other refugees that we are hosting in our country currently. But in recognition of the concerns of the UK Supreme Court, this is something that we specifically included in the treaty, whereby if people are not granted refugee status, we look for any other humanitarian protection that they might qualify for, and give them equivalent protection, although they are not refugee. The recognition that they are in need of humanitarian protection entitles them to the same rights and benefits of refugees. In addition, we did commit to not remove the persons that were relocated under this agreement unless we're removing them to the UK. So these are all safeguards that are in place to protect them against refoulement. Another requirement from the UNHCR is that the asylum seekers are to have access to fair and efficient procedures for the determination of their refugee status and or other forms of international protection. In the UK court, there's been a lot of discussion about the appropriateness of our asylum system. And in due fairness, our asylum system is quite different from the UK's. Most of our refugees, I would say 99%, are prima facie refugees. These are refugees that are coming in from conflict in large numbers. So you do not assess each and every person's refugee status. You do not assess each and every person's asylum claims. You grant them at face value refugee status. That's 99% of the refugees we have, and a very small portion goes through the individual asylum processing. These are individuals who are coming, from faraway places, mostly from the Horn of Africa, from the Middle East. We do receive these asylum claims, and they are individually assessed as opposed to being automatically granted refugee status at face value. And one of the concerns that the court was raising was whether we had the capacity to receive individual claims in such a large volume. And UNHCR described our asylum system, processing system, as nascent. What I would say to that is that, yes, our asylum system has only so far dealt with as few as 12 cases a year at times. But this is a matter of capacity building, and we were scaling up capacity in partnership with the UK. They were lending their expertise to us to be able to absorb such a large number, absorb and provide for such a large number of asylum applications. Another requirement is that asylum seekers are to be treated in accordance with accepted international standards, meaning they have to have access to health, education, and basic services. The accompanying documents of the MOU and the treaty was in the form of not-verbals, which were sort of annexes. And those not-verbals were detailing the access to health, access to adequate accommodation, basic service, education that the relocated individuals, the asylum seekers, will be entitled to upon arrival to Rwanda. It's so detailed that we even went into the types of personal toiletries they will be, the types of personal toiletries that they will be entitled to. So that's the level of detail we went into to make sure that they are treated in accordance with international standards and also our own standards as Rwandans. And the final requirement is that asylum seekers, if they are recognized to need international protection, they will be able to enjoy asylum and or access to durable solution. And that is, can you still hear me? I can't seem to access my Zoom.
We can hear you, Dr. Doris.
Okay, great. We have durable solutions in place. We've come to an agreement about the modalities of repatriation for those who will wish to reavail themselves the protection of their countries of origin. We also have modalities for the acquisition of citizenship, Rwandan citizenship. These are all, and we also, these are all part of the discussions for durable solutions, and they are included in the treaty. So the presence of these elements and how carefully we were in crafting these elements to include them in the treaty, it seeks to indicate the appropriateness of the asylum transfer. We've established that, concept of transferring asylum seekers to a safe third country is not illegal under international law, but is it appropriate? So it was this appropriateness that we really worked towards, and I believe that we've achieved. all those elements have been included in the note verbal and in the treaty. Some of these elements, most of them, are already guaranteed by Rwandan laws and our obligations under international law. The treaty expressly provides for these elements. Now you have, these developments in the UK in the form of the UK court decree Rwanda is not a safe third country based on the witness statements of UNHCR. Said statements were considered as expert statements, but not the statements of the government. So in essence, UNHCR is more of an expert on Rwanda than Rwanda is, which is, wow, that's the courts for you. That's their assessment. We do not recognize the Rwanda that was described in those court cases. Rwanda has always abided by its international obligation, especially human rights obligations. And regardless of of the politics of the UK, which are really not within our purview, we have no influence over of what is going on there. As a country, as a receiving state, we are ready to host and receive asylum seekers. We believe it is legal and it is morally right to do so. So I'm very much looking forward to having voices from the region, African voices, which are often absent in these discussions. So thank you very much.
Okay, thank you very much, Doris, for a very, very comprehensive presentation of the Rwandan side, or the Rwandan view of this of the issues that we are discussing. I listened to you very, very carefully, and I think the key issues that you talked about is where Rwanda is coming from. You've demonstrated Rwanda's clean hands as a country that has, it's a country of refugees, and so you're coming from a point of view of that Africans should deserve dignity, and if they come into a situation where they're refugees, there should be somebody else to help. So that's commendable. And also that a clarification that the intention isn't to process them for resettlement, for eventual settlement in the UK, but for settlement in Rwanda, and also you've given us the historical involvement of Rwanda in the Libyan migrant crisis, past migrant crisis. I think what, and then also you've talked about, which is very useful, the varying position of the UNHCR through this period, that the UNHCR position has changed from the time the negotiations took place to the time that the content of the agreement with the UK became public. What you did not commit yourself to very strongly is Rwanda's position about the UK's, where the UK's domestic politics, political disagreement leaves Rwanda under the circumstances. Rwanda needs to continue doing the good deeds that you've described, but I think where the disagreements internal in the UK leaves Rwanda under the circumstances, I hope when you come back to answer questions or further discussion, you'll be more clear about that. Let me now introduce Evans, allow Evans Ogada to come in and provide his own responses to what he has heard from the two presentations. Evans, you've got the floor.
Thank you very much, Mr. Kigoro. Good afternoon. We have to look at this new phenomenon of externalization for what it is. The conceptual West, global North, has been a master of doublespeak, whereby white refugees from Ukraine will have the doors flung open and received openly. But when it comes to the black and the browns, the rules change. I'm not saying anything new. And that is also true when it comes to the Palestinians, that one set of rules will apply for the Palestinians and their human rights questions, but will apply a different set of rules when it comes to others. Ladies and gentlemen, it's either we have international law and international order applying the rules consistently and as we know them, or none at all. My sister country, brothers and sisters in Rwanda, have entered into an agreement with the UK, and that agreement has to be seen from that perspective. The West wants to offload, quote unquote, their problems to the rest of the world. And that amounts to shirking international responsibility. If we look at the history of refugee and the refugee law, there is an international responsibility for sharing of the responsibility for taking care of refugees. That is an obligation under international refugee law. Rwanda, as it is, has its fair share of refugees. My own country Kenya, has hosted a lot of refugees here. It is only fair that the West lives up to its obligations under the Refugee Convention to shoulder the burden of hosting refugees. And the UK is not alone in this. We've seen instances in Australia, Israel, Italy, where the refugee question and the treatment of refugees is laced in racist undertones. We're not going to shy away from speaking the truth. We will speak truth to power. Now, what are the concerns that were raised by the UK Supreme Court vis-a-vis the Rwanda arrangement? The Supreme Court in the UK raised three questions. The UK Supreme Court said that Rwanda has a poor human rights record. That's the court. Then secondly, the court went on to say that there were certain serious and systemic defects in the asylum processing, as was agreed between Rwanda and the UK. Thirdly, another issue that was raised was that under similar agreements between Rwanda and Israel, the Rwanda government removed asylum seekers to countries of origin, meaning that Rwanda took back refugees who are fleeing quote unquote conflict situations, took them back there, violating the principle of non-refoulement. For those who are English speakers, the principle of non-refoulement, as known in Article 33 of the Refugee Convention, simply means this: you will not take back somebody to an area where this person is fleeing and claims asylum as a refugee or in any other capacity. So refoulement is contained in the Refugee Convention. We have Article 33 of the Refugee Convention. We have the Torture Convention, which at Article 3 contains aspects of the refoulement principle. We have Article 2 of the International Covenant on Civil and Political Rights, contains aspects of refoulement. Then we have cases that have been decided by the European Court of Human Rights that have interpreted the obligation of non-refoulement on the basis of the European Convention on Human Rights. to which the UK is a party. Of course, many of us will remember the case of Soaring versus the United Kingdom. This is one marquee case that has dealt with the principle of non-refoulement. Now, what are the concerns that have been raised in terms of what the Rishi Sunak administration is trying to do and the agreement they have cobbled up and tried to enter into with Rwanda? Now, the first question that has been raised is that the use of an international treaty does not mean that Rwanda is a safe country. Remember, the Supreme Court said Rwanda is not safe. So the opponents of this new arrangement, human rights lawyers in the UK, those concerned with international humanitarian law, are saying this, that Rwanda does not become safe simply by bringing in a treaty. The other concern they are raising is that the issue of safety is not a question of law. It's an empirical question that we have to look at the safetyness of Rwanda by way of examining evidence. That by just encrusting it in a treaty, that will not make Rwanda safe. Another concern that has been raised is that Rwanda has structural and endemic problems that cannot change in the short term. That these changes that were identified by the Supreme Court will have to be addressed, and addressing these problems will be a long-term concern, not a short-term concern. Another issue that has been raised with regards to this agreement is, and I think Sunil alluded to this in the beginning, was that there is an argument of violation of separation of powers, that the executive is trying to undercut the authority of the judiciary and the Supreme Court by going and trying to short circuit the sting of what the Supreme Court said. I look at this from an outsider's perspective, and perhaps I would want to respond to what my good friend from Rwanda said. Bilaterality does not obviate our obligations with regards to peremptory norms of international law. My good friend who spoke before me certainly is aware of Article 53 of the Vienna Convention of the Law of Treaties on the jus cogens provisions of international law. And it is correctly argued that the principle of non-refoulement is an aspect of jus cogens. Jus cogens cannot be scattered around, cannot be escaped by entering into treaty agreements. A treaty that does not accord to the obligations understood in jus cogens provisions becomes null and void by virtue of Article 53 of the Vienna Convention. We also cannot be seen to erode principles and norms of international law. If we are to introduce this emerging argument of third nation host states as a way of shirking international responsibility, let it be settled, let it be dealt with. My good friend who spoke before me certainly remembers this concept that the West has been trying to create, called responsibility to protect. The Global South has certainly resisted this. So I go back to where I started. we need to rely on principles and norms of international law and respect them for what they are. If the conceptual West will be cherry picking on what category of refugees they will deal with according to the norms, but when it comes to the Black and Browns, the Africans who are derogatorily called the boat people, the Afghans, the Pakistanis, that these are lesser categories of refugees, and therefore we have to boat them away, take them away from our shores. We are sending a very bad message in terms of the global order that has existed since 1945. I would certainly hope that these concerns are addressed and that we live true to international obligations in terms of truthfulness to the spirit and letter of the law. Thank you very much, Mr. Kegoro.
Thank you very much, Evans. A very, very clear and powerful rendition. Key issues you've raised, that the politics of this conversation race, different treatments of people who find themselves in asylum-seeking situations according to the races that they occupy. So Europeans dealing with certain races a particular way and dealing with other people a different way. And I ask loudly whether that is not also a part of how the UNHCR's different positions might be explained. That when the UNHCR is dealing with an exchange of asylum seekers between Libya or an African country and Rwanda on the one hand, or asylum seekers between the UK and Rwanda on the other hand, the UNHCR's own position changes because the unstated and undiscussed question there is the question of race, and that is the variable. And that is, and if that is the case, then I think that's something that probably needs to be discussed officially, and it's something also that Rwanda's national or domestic politics needs to show an awareness about and provide some kind of response to. I think that's part of what I hear you to be saying. The second issue you talked about is Rwanda's relevant record, Rwanda's specific past behavior that is relevant to the questions that we're discussing, that Rwanda then has behaved in a way that makes it difficult for these arrangements to be trusted. And that is, I think, something that, again, would be important for Rwanda to address in the way that it positions itself in relation to this debate. I will give the floor now to the last speaker, Donald Dare. You've got the floor.
Thank you, George. It's not that we're ganging up against Doris, but I find that I agree almost 100% with what Sushila Math and what Evans Ogada have said. So I'll just make some additional observations for emphasis. And I'd also just like to thank my friend Achieng Akena and also my colleague in the office, Esther Mwigai Mnaro, who are both on the call and who have contributed quite a bit to helping me crystallize my thoughts on this matter. I'll start with a question. What does this externalization agenda do for international law? Externalization of border management, which we're seeing a lot in North Africa and the Sahel. Externalization of asylum, which we're seeing in this instance that we're discussing today regarding the governments of the UK and Rwanda, but other examples exist. What does this do for the international rule of law? As you pointed out in your framing remarks, George, and also Sushila said, what does the approach of the UK government do for the international rule of law? When you have legal provisions that purport to oust the jurisdiction of the courts or to defeat judgments and orders of courts. What does this do for the rule of law, for separation of powers, for protection of human and people's rights? And my premise is that every nail that is hammered into any corner of the edifice of international law affects the whole of international law. As Evans has pointed out, last week we were all engrossed in observing the proceedings in the International Court of Justice, where we agree with the government of the Republic of South Africa. There's an attack on one part of international law, the Genocide Convention, and provisions against apartheid. Today, we are focusing on another part of international law, international refugee law. And I must say that I agree with the analysis of the United Nations High Commissioner for Refugees on this agreement. And just to point out that the analysis was actually updated 2 days ago. The updated version is published on 16th January 2024. And to say that we should protect all parts of international law or the entire edifice of international law goes down in our watch. To step back a bit and talk about, as Dr. Doris said, not just from a legal point of view, but from a social point of view, from a policy point of view, from a sociological point of view. This migration narrative, it is very sad that the African migration narrative is often told from a Eurocentric perspective. We focus on what Europe wants and what Europe says. So the focus is on legal pathways rather than free movement. The focus is on mobility, you know, as defined by them. Even a lot of the published works, even scholarly works that are being focused on, they focus, that written mostly by Europeans, and they focus on the European perspective to it. And we focus a lot on migration from Africa to Europe to the exclusion of other migrations. And we lately talk of migration as a crisis. Is it a crisis? The UN itself, UN bodies have said, and lots of other actors have said, 75% of migration is within Africa and the global south. Only 25% goes to the global north. Is it a crisis? The problem with this externalization agenda of border management, of asylum, is regardless whatever might be the stated good intent, what ends up is that it creates incongruences in national policies, in regional policies, in continental policies for Africa. And these incongruences, it is in these corners that human and people's rights are violated. And that is our complaint. First, the migration that we have is mixed. There are different types of migrants, and within them, there are asylum seekers, but they use the same routes, they use, you know, the same methodologies. And it is very hard to say that you can disaggregate the impact that this has on those who are forcibly displaced vis-a-vis those who are migrating for other reasons. There's also a risk of a domino effect and a risk of a race to the bottom, as we have seen with the externalization of border management. As we can say, as we can obviously admit, Rwanda cannot handle all the prospective migrants into the UK. It can only handle a small portion of it. So where do the rest go? So what we will see is a pressure for other states, including other African states, being pressured to enter into similar agreements in order to deal with more of what they're facing. Already we are seeing governments being more oppressive and taking greater liberties with their human rights commitments. That's what the Western states are doing now. I think Evans has illustrated sufficiently the differentiation in treatment between refugees and asylum seekers coming from Ukraine, vis-a-vis coming from Syria, vis-a-vis coming from Libya, vis-a-vis coming from Sudan and other places, you know. So we are seeing the effect of these agreements leading to results that are not salutary. In Niger, as part of the externalization of border management idea, they came up with this 2015 law, the law on illegal smuggling of migrants, which was funded by the EU under their emergency trust fund. What ended up happening is that it mixed completely different types of people who are migrating for different reasons, and it mixed completely people who are ordinarily just migrating into Niger vis-a-vis those who are being migrating through Niger as a transit to going somewhere else. So it is no wonder that one of the post-coup reforms has actually been the abolition of this law. In Libya, the agreements that have been made are, on the one hand, agreements have been made with the transitional government in Tripoli. But because of this panic around a crisis of migration, agreements have also been made with the warlord, Khalifa Haftar, therefore ending up giving some legitimization to a warlord and ending up presenting Europe as not having a principled engagement on issues of democracy, governance, rule of law, peace and security in Africa when you're legitimizing and financing a warlord, you know. So we see this externalization agenda as a threat to multilateralism in Africa. As we indicated, we stand by the UNHCR analysis, but I also highlight that on top of creating problems for the UN Convention, this agenda creates problems for the OAU Convention on Refugees, the 1967 Convention. It creates problems for the AU Convention on IDPs, internally displaced persons, the Kampala Convention of 2009. And it creates serious complications for the AU Migration Policy Framework for Africa and the Plan of Action. It is complicating regional integration. It is complicating continental unity. One specific thing that I'll say about the impact that we fear for Rwanda, I grant that we have been informed that Rwanda is going to update its asylum law, and it may contain provisions that may address the question that I'm answering. But one thing that we're not sure of is, will there end up being two categories of asylum seekers and refugees in Rwanda? Those who had naturally sought refuge in Rwanda vis-a-vis those who are being brought from the UK. How will this be handled? Will there be one regime, or will there be two regimes? And two regimes obviously will contravene the non-discrimination clauses of the OAU Refugee Convention, of the African Charter on Human and People's Rights. The final thing that I will say is responsibility sharing. And just to repeat, because this is a point that Evans Ogada had also made, 75% of the movement is within Africa, and we're bearing it stoically. Why should we be forced to bear the other 25% when the obligation to solidarity is for all of us globally? Why should we allow this distortion, this domino effect, this race to the bottom, because somebody has decided to define this as a crisis for them, but that which they want to outsource to others? In light of the challenges that this is posing to AU policies and AU law, frankly speaking, one of our considerations is to further litigate this thing in Africa. At the African Court on Human and People's Rights, or the African Commission on Human and People's Rights, so we make clear, we let the courts and the commission make clear what are the obligations of African states vis-a-vis what are the obligations of other states. George, perhaps I stop there and we democratize the discussion.
Okay, thank you very much, Don. You brought in additional very useful insights, including the proportionalities involved, making the point that the largest proportion of asylum seekers don't leave the African continent, 75% of those, and the ones that end up in Europe are only a small portion, and Europe wants to push back those exclusively onto Africa. I guess that goes down back to the points that Evans made, that Europe is cherry picking, and the guess is the only reason why it wants to pick to confine them to Africa is because of their race. Again, that's a theme that has come powerfully. I think you've also talked about how Europe has European countries have conducted themselves in relation to what they've defined as a crisis by getting into a very unprincipled and pragmatic set of relationships with individual African countries that then systematically undermine the obligations of those countries, both under international law and also under relevant AU law in relation to refugees. And of course, you've said that this is something about which Africa should have a say, using its own institutional mechanisms, and said that maybe this is something that should be litigated in Africa. So thank you very much for that. There are some people who've written in the chat. I don't know whether I'll be able to get everything that has been said. Let me just pick and choose some of the things to say. There was there's, I think, a response that Rwanda is a safe country. That is a defense of Rwanda as a safe country for asylum seekers. And there's also an assertion that Rwanda's judicial system works and has proved itself, and therefore is able to play its role in protecting the arrangements between Rwanda and the UK. There was a question to do with if this arrangement between Rwanda and the UK is wrong. Can somebody suggest an alternative that is viable and that is able to deal with the abuses that the arrangement says it is trying to respond to? I think those are two of the themes that, two of the key questions that have been raised in the chats. I think it's time now to open it to the rest, so to the silent majority who have been listening. If you've got a question to ask or a comment to make, you can, by a show of your hand on the chat, indicate, and then I'll give you a chance to speak. Anybody in the silent majority that wants to say something? Okay.
Mr. George, there is one Mugabe Ivan.
Okay, Mugabe, go ahead, Mugabe Ivan.
Mugabe, you can unmute and speak. Mugabe Ivan,
hello.
Just
yes,
unmute.
Can you hear me?
Yes, we can hear you.
Yes, my question is in relation to some of even the definition, I think, of externalization, in as far as how Rwanda is perceiving this. I think especially Doris's presentation, what doesn't really come out clear is whether the voices of these refugees or their experiences really matter, because it's becoming more of a state bargain, an exchange between states in terms of we exchanging these human beings, you can have them, we shouldn't have them. I'm just sort of wondering, because we are dealing with human beings with human rights, and if discussions are happening between interstate or government levels without really putting the subject's views or experiences at hand, then I feel maybe there is something which is not being done right. So I'm just wondering where, because they are powerless, they are helpless, and in many cases they are vulnerable, the refugees. So it's a delicate issue, and that's perhaps why maybe an understanding of whether there has been a very clear consultation will be key in their views. And then secondly is about I think this has been raised by, I think, Donald and also Evans, the issue of the silence by the African Union, by this African community, by these different organizations across the African continent, because that silence is problematic, because we need to know this would have been an opportunity for them to be clear whether they condone or they condemn what we are seeing in terms of Rwanda being an ally on the other ends. So because again, what we are saying, that there are other African state, and I think this Evans has highlighted, which may actually emulate this approach. So we are seeing that it's a little bit laying a different landscape in as far as refugee issues are concerned. And so if there isn't a clear statement whether this is something good or bad from regional actors across the continent, then it may seem as if this is something condoned. And tomorrow maybe Kenya or maybe Nigeria or maybe Togo may say, okay, we enter into an alliance with friends. So I think it's something which maybe clarity must be made, and I think boundaries must be drawn. Thank you.
Okay, thank you very much. I see a hand from Peter Herbert.
Hello, yes, thank you. I just wanted to say that I was and have been an observer of these proceedings and the shenanigans by the UK government and indeed the Rwandan government for the last several years. I was an immigration judge in the UK for 24 years, since 1996, actually, until I retired in 2020. Proud to be a member of PALU, proud to be a Pan-Africanist. And I cannot think of any person of color in the United Kingdom or person who was of any progressive persuasion that supports this policy. It is primarily a means of dumping people of color on the African continent. In fact, dumping them anywhere in the global south. And it amounts, in our view, to state trafficking of people. Nothing more and nothing less. The way in which it's been couched is in terms of serving, as Donald said, a crisis. There is no crisis. Europe takes less than 1% of the world's refugees and has 25% of the world's resources. And the danger of this type of policy being authorized is if it then flows to the election of Donald Trump, is he then going to dump 12 million Hispanics on any South American or African country that he is able to pay the dollars to take them? And therefore, what you do is you have underlying this is a policy of keeping Europe white, maintaining it white. And therefore, if Rwanda, as a supposedly liberal, supposedly a democracy sitting in the heart of the African Union, it makes President Kagame and any apologists for him a party to the very worst racism that he claims, and the historians are well aware, would lay behind the Rwandan genocide, not just of Tutsis, but of moderate Hutus and others in that country. It was designed, practiced, and orchestrated by Belgium and France and the European powers. And this, in a sense, is the latest attempt to engage with, and they did try, I should say, with Kenya. My information is Kenya rebuffed the overtures of the United Kingdom, quite rightly. They tried the island of Antigua in the Caribbean, and they were also rebuffed. And I think there were several other states. But my deep concern is that this is political expediency. It is also, I'm paying, as a UK taxpayer, some of this £400 million, which has been given to Rwanda to do virtually nothing. And I was dismayed, and I asked the question that one of the things that shocked me, and in fact shocked the Supreme Court, when there was a peaceful demonstration, I believe in 2018, the Rwandan security forces shot 14 asylum seekers, 14 dead. And that doesn't mean to say that there were not other instances of police brutality. I visited in recent years, and sadly, Rwanda is not a beacon of the recognition of human rights, even of its own citizens. I dealt with many Hutus and Tutsis who claimed asylum over the years after the genocide, and they would have been appalled if they had been told, well, actually, no, you're not going to have asylum in the UK. We're going to dump you in Mauritania. We're going to dump you in Bangladesh. We're going to dump you in the DRC or in any third country where we, as a parliament, deem it safe. And this is all about the race to the bottom in the UK, about the Conservative government, which has been in place 14 years. There's a backlog of 98,000 asylum seekers, less than 20,000 crossed the channel. And just one final point as I close, is that the representative doctor from the MOJ in Rwanda spoke of the fact that in her introduction people claiming asylum in the UK crossing are unlawful. No, they are not. Article 1 of the Geneva Convention gives a fundamental right to a person to claim asylum. What happens thereafter, the asylum claim is either upheld or rejected. They are never, repeat, never unlawful. And no legislation in the United Kingdom or Rwanda can make that so. So the whole premise for that introduction is biased, it is highly politicized, and I challenge anybody in Rwanda to have any record of speaking out against this policy. They would not be permitted, and they would find themselves charged with whatever offense and have the pleasure of having to seek asylum outside of Rwanda at the earliest opportunity. So reflect on the reality of where you're taking this analogy and debate. Thank you.
Thank you very much, Judge Peter Herbert. I think really those are very clear. I think Evans is applauding every point that you've made. And I don't know whether there's another hand up before
There
we
is
go back.
There is Mr. Cheng. I think you can pick. We have already taken 2 questions. You can add one more, and
I think let's take one more, and then we can go to the panelists.
We have Achieng Akena.
Achieng Akena.
Thank you very much, George. Thank you, the panelists, for a very interesting discussion. Again, I agree with many of the opinions that have been given previously, particularly by the panelists and the previous speakers. I align myself with a lot of those comments, and particularly as a Pan-Africanist, I really have to ask myself why we are, why particularly Rwanda has been fronting or has been forefront in the drive for Pan-Africanism and regional integration, would be accepting a deal that is clearly about, it's such a racist deal that is clearly about keeping Africans in Africa. Already we bear such a huge burden in terms of refugees and migrants, and principles of burden sharing and global equality require that the so-called rich countries also equally bear their responsibility to the global community, which they are shirking by using these deals. We've seen other European countries also seeking similar deals with Uganda, Rwanda. We've seen the US transferring its Afghan refugees for processing in Uganda, and so forth and so on. So we have a whole sort of, flood of this externalization policy that really goes counter to what we seek to achieve towards Agenda 2063 and towards creating an Africa that we want. If we're looking at emergence of the continent as clearly stated within the Agenda 2063, why would we accept situations whereby, or situations that clearly hurt the continent in terms of allowing our European partners to shirk their responsibilities towards us and towards the global community at a time when we are still recovering from colonial and neo-colonial policies that have set the continent behind. And I think my last point being that when the crisis, quote unquote, began in 2015, the response of the African Union was to actually, increase legal pathways for migration by insisting on the adoption of the Free Movement Protocol. So this deal seems to fly in the face of the efforts and policies and decisions that the African Union has made in relation to migration and in relation to free movement as a key component of Africa's self-reliance and development. Thank you.
You're done, Achim, I think. I think you can get the panelists to respond to some of the issues that have come from the floor, which include question around where is the voice of the refugees in all this. There was also what Peter Hubbard said. This seems to be trafficking by states, human trafficking by states. I think that's how he has characterized it. And then there's also the sharing of obligations by states, which this arrangement seems to be flying in the face of. And then there's a question around the voice of African institutions, and then the arrangement between the UK, by according to Acheng, undermines Africa's own the continental arrangements with regard to refugees. I think that's again something that's Don talked about earlier on. So I think we give Sushila first, and then Evans, and then Don. Then we can, Doris, you can have the last word on this round, and then if we have enough time, we can get another one more round of responses from the audience.
Thank you. Yeah, I just wanted to say as well, thank you for the comments. I wasn't able to respond to them in the chat. And I just wanted to make a couple of comments on the points about racism and also about the illegal aspect of migration, just to point to some authorities. Firstly, the African Common Position on Migration and Development really kind of focuses on the fact that historically migrants have been deprived of their rights and subjected to discriminatory and racist actions and policies, both in transit and destination countries. And it states that the management of illegal and or irregular migration should not jeopardize the human rights of refugees and the principle of non-discrimination. And you know, in the 1951 Refugee Convention, Article 31 does talk about not imposing penalties on account of illegal entry. And similarly, the English Court of Appeal has previously made it clear that little attention should be given to how directly somebody got to the country, and that it shouldn't be confused with the safe country kind of inquiry, and that it's also difficult to reconcile that type of point with the presumptive right of refugees to choose for themselves where to ask for protection, which the English Court of Appeal said was a principle built into the structure of the convention itself. And the travel preparatory for the 1951 Refugee Convention noted that a refugee whose departure from his country of origin is usually a flight is rarely in a position to comply with the requirements for legal entry into the country of refuge. And so I think really taking that into account in this debate would be helpful as well, of like the fact that, you know, some people that they don't have any other options of how to reach somewhere, and that's really something to be taken into account. And just very quickly taking on Donald's lead, I'd also like to thank my colleagues who've been working on this issue at our end as well. So Waikwa, Mena Suarez, Manik Minhas, Maria Pajaro, and also Dan, who helped project our slides today. Thanks.
Let's have Evans.
Thank you. Responsibility has to be shared. Part of the problem that the conceptual West has been having with the Prime Minister of Hungary, Viktor Orban, and countries on the on the eastern frontier is on sharing. Let us share the responsibility. My colleagues on the side have clearly stated that Africa has borne its fair share of refugees. We hold around 70–75% of refugees in the world. It cannot be that others will shy away from their responsibility and choose, cherry pick which sort of refugees to pick from. When it comes to Ukrainian refugees, we will open doors. But when it comes to the black and browns, we change the rules midstream. Inherent in the obligations of countries is to process refugee claims when they appear in your territory. So the issue of their being safe destinations where these refugees could have landed does not arise. When somebody appears in your country and makes a claim, you have the obligation to process, at least give due process to that refugee and see whether they are candidates for hosting or they can be returned back to wherever they are coming from, and to maybe a third country where they landed first. And I think, was it Donald Dare who raised concerns about the ouster clause in this UK-Rwanda arrangement, whereby the jurisdiction of the UK courts has been effectively been ousted. And that's quite a dangerous proposition in terms of international law. There are two questions that have been posed to me. I'll want to respond to them quite quickly. What can the AU and the East African community do to prevent countries from becoming negative allies? Basically, we can come up with multilateral agreements to ensure that we approach the question of, if we so seek, hosting refugees from other countries together. But again, that will raise issues with regards to the principle of non-refoulement. If countries choose to go bilaterally, that will be for them and according to the internal policies. We have to remember that Africa has never had a problem of hosting refugees. Students of history will remember that we have a document from the Mande in West Africa, a document called the Kurukan-Fuga, 1263. It's a constitutional document of equal significance, if not better, than the 1215 Magna Carta from England. The Kurukan-Fuga 1263 has elaborate provisions to protect women, to protect refugees, to protect diplomats. A very rich document. We have shown throughout the years that Africa can take care of refugees. By deed, we have been hosting our refugees here. On behalf of the international community, we have no problem. So we will continue doing that. The objectives of the UK-Rwanda agreement, I don't know. Mine is to just probably urge my brothers and sisters in Rwanda to see through some of these things that the West tries to get us involved in. One of the saddest things I have ever seen in terms of the treatment of the African person was this lady from, I think, Zambia, who was stripped naked in the Negev desert by the Israelis and hosts literally sprinkled with water as if she was vermin and less of a human being. That is how Africans are treated in this part of the world. And for my generation, we will speak out and we will remind them that the African person, the blacks and brown, deserve dignity like any other. Thank you.
Thank you very much, Evans. Donald?
Thanks, George. There's not much to say. I endorse what Acheng Aken and Peter Herbert have said. So just two things. I'll reiterate that this approach of externalizing borders and externalizing asylum that we're seeking and trying to lock people into certain countries that they can only stay there, it complicates the free movement agenda of Africa, which is an integral part of the African continental free trade area, but also of the various free trade arrangements of the regional economic communities. It really complicates it. And this whole agenda, for me, has a similarity and needs to be read with another con act that we're getting, the climate con, where we all agree there's climate change. We all agree we must reduce global warming, meaning we must cut down on our emissions. But our colleagues from the global north are saying they won't cut down on their emissions. Rather, they will buy carbon credits from us. So it is us who are being told, don't touch your forests, including extend your forests, remove forest dwelling people, so that we feel that we have trapped carbon there, so that we keep our life the way we have it there. So I see the parallels between these cons, and I just urge all African states and all African peoples not to fall for it. And as I said, because of the complications it raises for various countries, we should also consider litigating it in countries, regionally and continentally in Africa. Thank you.
Doris, very, very strong view about the behavior of Rwanda, including a view that is Rwanda, nobody in this conversation thinks that Rwanda is naive. It's a very sophisticated country and is able to think through a lot of the issues that have been discussed here. So it can't be an act of lack of sophistication that that leads to this arrangement. What are your responses to the race, the racial discourse that is clear around the conversation that we are having, and also the other things that have been said about Rwanda's how Rwanda is perceived in terms of its domestic and regional dynamics and the safety first of its own nationals and the critics of its government, and how that position Rwanda as an honest broker on asylum seeking.
Thank you. Don't know where to start. I feel like all the questions are aimed at me. You know, that's why we're here. I think I would say, for instance, I just want to pick up on Evan's point about circumventing peremptory norms of international law through treaty. It seems it is a foregone conclusion that this is a treaty to exact refoulement, which is completely untrue. People will not be refoulement. We do not practice refoulement in Rwanda. So people who are relocated to Rwanda will be assessed for their refugee status and granted refugee status if they qualify for it, if they have humanitarian protection, granted that, or any other status. And as part of these measures to ensure that there is no refoulement, as you mentioned, is to make sure that even if in the off chance that a person who should otherwise receive refugee status and has not been given refugee status, how do we protect them from being sent back to their country of origin? We have arrangements with the UK that if they have to be removed from Rwanda, the UK would take them back. So refoulement is a non-issue here because we are committed to our international obligations. So this is not a treaty intended to circumvent our obligations. And I picked up on a point about how this impedes on the free movement of goods and people in Africa. And I don't think Rwanda has lessons to receive about free movements of goods and people. If you recall, we were pioneers of the visa-free movements of people here. So we've always been champions of free movements in the country. We've championed the the Continental Trade Agreement. And people who are coming here under this this partnership, they're not going to be just parked in Rwanda, unable to move. They will be given travel documents for those who do not have it, and they're free to use their travel documents and circulate about. So I do not see how the relocation of these people to Rwanda impedes the movement of people. Nobody is brought here to be a prisoner in this country. They can move freely within and outside of the country. Another point that kept cropping up is how can Rwanda be part of such racist policies? How can Rwanda not see through the schemes of the West? And thank you, George, for pointing out that we're not a naive country. I think give us some credit that we also have our own agency as a people, as a country. And we're going into this partnership with our eyes wide open. How can it be racist to receive Black and brown people? All the examples that are given of racist treatments of refugees are their treatments outside of Africa. within Africa, I would say, as Evans gave as an example, we've always been able to take care of our own. We're receiving refugees. We're receiving Black and Brown people here, and we want to give them these opportunities to live dignified lives, as we have done, as we've been able to do so as refugees, or as we would have wished to be given that as refugees as well. And so I really do not see how you can say that Rwanda is racist for receiving refugees. For instance, if you consider some of our policies that are really intended to accommodate people in an environment that wants to accommodate them. It's an environment that wants to receive them. We have the school for Afghani girls. When Kabul fell and this school was in jeopardy because, you know, the Taliban are very opposed to the education of women and girls, we relocated that entire school, not just the students, but their families as well, all live here in Rwanda. So this is just a continuation of our project of Rwanda and Africa being an area of solution. If people cannot move about freely in the West, they can do so in Africa. I don't know if I missed one of the other questions, please do point it out.
Yes, you did. Yes, you did. This question to do with whether Rwanda is going to have two streams of asylum seekers, those who
yes.
Rwanda and those who choose the UK and are then brought to Rwanda.
Yes, and thank you so very much, Donald, for this question. And I think and this is something that was part of all the discussions that we were having, even with the UK, with our UK counterparts, when we were coming up with this arrangement, is that we do not wish to create any parallel systems. So what is applied to the relocated individual is applied to asylum seekers, even as we're working to build our capacity for asylum processing system, to build our capacity to reform our laws. We want this to be applicable to all asylum seekers who come to Rwanda. And that was one of the key considerations, that we are not going to create a parallel system. And this scheme actually, even though this scheme benefits all asylum seekers and refugees in Rwanda, the reality of this partnership is, yes, people are relocated. Yes, we are very willing to receive them, but housing, feeding, giving healthcare to people, these are things that cost money. And as part of this partnership, there's also an economic development consideration. So some of this money is going to be used for the economic development of Rwanda as a whole, which benefits all who reside in Rwanda. So this is not going to create a parallel system, either in laws or in the institutions. And this is going to benefit financially. Other refugees are going to benefit from this scheme. Yeah, so that would be my answer to this question. But Donald, if you have any follow-up question, I'd be very, very interested.
Okay, I think we are almost at time. Don, do you have anything to say, because you've been pointed out to, before we sort of wrap up?
No. Just to say thank you, Doris, for that answer. And yeah, we'll continue engaging. I have no further question at this moment.
All right. I'm disappointed that we don't have time left for an additional round of responses from the silent majority, but also heartened by the fact that the time is very, very well spent, because we've had an extremely insightful panel that have provided. This is a panel of practitioners, because they've been involved in the formulation of the arrangements between Rwanda and the UK firsthand, that is in the person of Doris, but those who have also questioned that, like Sushila and the East African Law Society. So it's an extremely practical conversation that we are having, and I feel that it is a conversation whose clarities will contribute directly to improving what we are all trying to work on. I think, to say this, Africa is not just the biggest I mean, it is not just host to the largest slice of the refugee and asylum seekers in the world. It is also the largest source of those refugees and asylum seekers. So that is a point that I think needs to be made. The other point to make is, and arising from the second point of Africa as a source of refugees and asylum seekers, is what is Africa's credibility to provide asylum-seeking arrangements that are credible, given the fact that its domestic situations, practices, and circumstances are such that it is such a high net producer of asylum seekers and refugees, and also the fact that Africa is a very poor continent. And I think those are questions that are not necessarily directly asked, but that are important to raise and say, Rwanda, a country that has significant domestic and economic challenges, what is its place to be the sort of the global interlocutor on asylum seeking, or to be an interlocutor with the UK, a world power that is trying to shirk responsibility. So the question there is Rwanda really not punching above its weight? I think it's not raised that way, but I think it's probably a concern that is worth reflecting on going forward. I accept the motivation that Doris says are behind the position that Rwanda has taken, that there is a responsibility to protect the dignity of African people, and that Rwanda is taking a global leadership in that. And there's also the dignity, there's a responsibility to protect the dignity of brown people. And again, Rwanda is taking global leadership in that. But if you've got to go back to the question of why Rwanda, which is a relatively disadvantaged country, when there are countries that have got far more resources and that are far more equipped to play that role. But again, back to the question: if Africa's circumstances are such that we are also refugee and asylum seeker producing, what is our credibility to also then be the leader in the global conversation that under the circumstances? I don't think there are easy answers to any of those questions, but I think they probably constitute food for thought as we go forward. I would then conclude by thanking the panelists, especially Doris, but that is not to say that any of the others are less valuable to this conversation. But this is because it is not often that we get representatives of governments coming to explain their position. So your presence today is particularly valuable for that reason. But the other panelists, for the insights that they brought and the clarity that they've shared in this conversation, I also thank you heartily. And I don't think anything has been resolved. And I think that this is a sort of an adjournment, and the conversation is going to continue in other places, including, I suspect, in court. Thank you very much. I hand this back over to the organizers and thank them also for the opportunity I've been given to moderate the session.
Thank you, moderator. Thank you for moderating this wonderful webinar. Mine is to thank our panelists who have agreed to share with us their experience and expertise on this new phenomena on externalization of asylum and principles governing asylum seeking. And most importantly, we have had an opportunity to hear the analysis of the UK Supreme Court judgment on transfer of asylum seekers. Some members in the Q&A chat have been requesting for this judgment. Shall be sharing the same. Panelists, your presentations have been very well enlightening. And on behalf of the ELS Council and on behalf of the ELS Secretariat and all of our members, we thank you very much for always being available to offer your expertise and advice on diverse areas of law. And we expect to be reaching out to you soon in other webinars to follow. To our members, we thank you all for attending our webinar in good numbers. This is our first webinar for the year, and we have a lot more coming. We urge you to keep a close eye on our social media, where information is shared regularly. Meanwhile, you can follow us on Twitter, Facebook, Instagram, and visit our website where regular information is being uploaded. And if you missed any part of this presentation, the recording will be shared in our YouTube channel. You can subscribe and listen to any session that you might have missed. To our partners, PALU, the Open Society Justice Initiative team, thank you all for assisting us to put up this webinar. I would wish to tell you that the presentation and the recording of this webinar will be shared to your emails. So don't worry, we have your email address and we shall be able to share the same. And with that said, I wish you a good evening and see you in our next trainings. Till next time, bye. Thank you.